exciting. Hi, good evening, everyone. We're now live on Facebook. Welcome to the first webinar that Philippine Bayanihan Society is organizing. We used to have our Bayanihan talks, but because of COVID-19, we all have to stay at home or at least work from home. So as we try to continue serving our kababayans, the board has decided to do a webinar. So the first one will be an issue on employment laws in Singapore, which we will have Atty. Ranvir as a speaker. But before that, let me talk about what Bayanihan Society does. We have a building called Bayanihan Center at 43 Pasir Panjang Road, which is very near Labrador Park MRT. And that 4-story building has been there. Actually, it's an old building, and we have upgraded it, and it's turning to be quite a nice building. It's a home of Filipino overseas workers, PAWs, where they teach sewing, cooking, we have aromatherapy and other courses. We also have, it's also the home of Ateneo LSE, our leadership and social entrepreneurship course. And that's a very popular course among our kababayans, OFWs. There's also a room for tambayan. So if you have a party, if you want to have a meeting, you just inquire with our secretariat, our Bayanihan ladies. So you can have a room and use the tambayan. We also have meeting rooms, mailboxes available for our field orgs. And also, there's a nice photo studio where you can take your portraits. Take advantage of that because it's just one of the few kinds that we have offered to our kababayans. And also help our OFWs get, since Bayanihan is mainly for skill upgrading and training, we also conduct talks to get better understanding, like benefits of OWWA, or SSS, pag-ibig as well. And also we had a talk on the Philippine art in Singapore at one time last year. We also do history talks. So we had Professor Ambet Ocampo the other day talking about women in C. Rizal's life. And also, I'm sure everyone is aware that we do have our Bayanihan Walk, which we do every year. We had it for 5 years. This year, maybe, let's see how it goes with our COVID-19 outbreak. And well, let's see. And also, we had our inaugural Bayanihan lecture last year. We had Dr. Anton Marie Lim of Yellow Boat and Mr. Sam Al-Shama, who talk about social work, and of course, our very own Atty. Ranvir, who talk about volunteerism. He's a very strong supporter of volunteer work. And so, now we have these webinars. As you see, we have to do everything virtually, online. We can't meet face-to-face. So this is now the thing that we do. So we can still continue to share expertise, knowledge, and other information that we can share with everyone. So that's what Bayanihan does. And before I give you Atty. Ranvir, let's have a few words from His Excellency Ambassador Joseph Del Maria, who is with us here. Please.
Thank you. Good evening to everyone. Warm greetings to Atty. Ranvir, Kumar Singh, and all the other participants to this webinar on the understanding of the employment laws of Singapore. I would like to thank the Philippine Bayanihan Society of Singapore for organizing this online forum, this webinar, which is the most recent of its many events geared to deepen mutual understanding between Singapore and the Philippines. This forum on understanding of the employment laws of Singapore is very significant and timely, especially during this period when businesses and jobs are being disrupted and affected by COVID-19. I'm very certain that everyone who is attending this webinar will learn and benefit from the expertise and observations of Ranvir, whose experience spans many years and covers many sectors. Ranvir's understanding and perspective of Singapore's employment laws are enriched by his experience in arbitration, civil and commercial litigation, employment law, and workers' compensation claims. So I wish all of you an insightful and learning-packed time during this webinar on the understanding of the employment laws of Singapore. Thank you and good evening.
Thank you, Ambassador Joseph. Yeah. Before I give the floor to Attorney Ranvir, let me just talk about him. Attorney Ranvir graduated with an LLB with honors from National University of Singapore, and he also has his LLM master's degree from King's College London. He has a diploma in financial management from SIM, a diploma in international commercial arbitration from Chartered Institute of Arbitrators in London. This is already a long, impressive list. And he was admitted to the Singapore Bar in 1985, and since then he's been practicing law. Besides that, besides being a lawyer, he has definitely considerable experience in a wide spectrum of legal matters, including large, complicated cases. He was also involved in cases in the superior courts in Singapore, as well as the International Court of Arbitration of the International Chamber of Commerce, Singapore International Arbitration Center, Hong Kong International Arbitration Center, and Singapore Mediation Center. It's a long list of impressive achievements. And Attorney Ranvir is fluent in English, Hindi, and Malay. That's a lot of things, even Chinese dialects he can speak. So maybe some of you can speak with him in dialects, except maybe, I'm not sure, he knows some Tagalog, but let's see. And of course, he's very, very active in social and community work and holds key positions in a number of organizations. He is currently the president of Philippine Bayanihan Society. And so without further ado, I give you Attorney Ranvir Kumar Singh. The floor is yours, Attorney Ranvir.
Thank you, Minnie, for the very kind words. Good evening, Ambassador Joseph Yap, and good evening, ladies and gentlemen. And on my part, and on behalf of the Bayanihan Society, I welcome you all to this evening's webinar. Now, Minnie has already outlined the sort of work that the Bayanihan Society has been doing. And the question then arises, why this webinar? Well, over the last few months, because of the issues created by COVID-19 and that most of us are working from home. So we thought that this webinar will be another medium for us to engage with our constituency, those who have been using the Bayanihan Center and those who have been attending the activities of the Bayanihan Society. Because of the pandemic, they are not able to do so. So this is an avenue for us to continue with our engagement. And through this engagement, we hope that we all can learn something new and share our ideas so that we continue to upskill ourselves. And then at the same time, we can share issues and discuss issues which are of topical interest. And that brings us to this evening's discussion. And this is on employment laws in Singapore. So I hope by the end of this session, you'll have some idea about the employment laws of Singapore. And if there are some doubts or queries that you have, we'll be happy to, remove those doubts or answer your queries. So I propose to make this presentation broadly in 3 parts. The first part, I'll cover some very general basic stuff about the employment laws of Singapore. And the second part, I'll touch on the impact which COVID-19 has caused to employment matters. And the third part will be where we field questions from members of the participants. So let me now turn to begin the presentation on the first part. Could we have the first slide, please? Now, let me begin by addressing the issue of who are the people who are covered under the Employment Act. Now, I must say that, first of all, there are several statutory provisions which govern employment matters in Singapore. The main one is the Employment Act, which covers practically all employees, as you will see below here. And then I'll go through in more detail. And the second one is called the Employment of Foreign Manpower Act. Now that covers basically for foreign workers who are in Singapore. Now, coming to the Employment Act, who are the people who are under the purview of this act? First, it covers all employees, whether they are permanent or part-time or temporary. As long as they have a contract of service with an employer, they are covered. Now, we need to draw a distinction between an employee and independent contractor. Independent contractor is not covered under the purview of the Act. What do we mean by independent contractor? They are basically people who run their own businesses. They may be engaged by a particular company to do a certain project, and they just work on a project basis. They don't come under the command and control of a particular employer. So they are called independent contractors. Sometimes it is maybe difficult to draw a line, but the distinction is there. So long as a person is an independent contractor, that person doesn't fall under the purview of the Employment Act. Now, next, what we do, so we have two different kinds of workers who are, one is called workmen. What is a workman? A workman is basically a rank and file employee involved in manual labor, for example, a construction worker. And then we have another category called non-workmen. This is a rank and file white collar employee, example, a clerk. So both workmen and non-workmen, they come under the purview of the Employment Act. Now, another category of people, what in short they're called PMATs, professionals, managers, executives, and technicians, they are now included in the Employment Act. Earlier on, some years ago, they were not included under the Employment Act, and there's no cap on the salary of this particular group of people for them to fall into the purview of this act. There are some categories of employees who are not included, and they are basically excluded. Essentially, they are one, public servants, domestic workers, and the third one are seafarers. The reason why they are not covered is because they are covered in other statutory provisions. So therefore, they do not fall under the purview of the Employment Act. So that's the basic framework of kind of employees who fall within the purview of the Employment Act. Foreign domestic workers would fall under the purview of the Employment of Foreign Manpower Act. Right. So let's move on to the next slide, please. Now, this relates to employment records. Now, there was some time ago, employers did not maintain proper records for employees, or did not provide proper documentation for their salary slips or their paid wages and so on. So right now, the statutes have provided for that employers have to maintain proper employment records. For example, written terms and conditions of their service. Is essentially they should sign an agreement between the employer and employee, and employers are bound. They are obliged to give written pay slips to the employees. So this provision is quite new provision, a couple of years ago, when this was inserted in the Employment Act. Okay, let's move on to the next slide, please. Now, this deals with salary. So salaries of employees have to be paid within 7 days after the end of the salary period, right? And any deductions from salary can only be made with the consent of the employee, and that the consent can be withdrawn at any time. Of course, I would add here that there are certain deductions which can be made under the statute. For example, CPF contributions, contributions towards, for example, the MUIS Mendaki, and the Chinese Development Association or SINDA. Those are statutory contributions which the employer is bound to deduct and pay off to these particular organizations. Apart from that, there can be other deductions. For example, if the employer is providing for accommodation, for example, but that has to be with the written consent of the employee. Without the consent of the employee, the deductions cannot be made. The third point here is the overtime rate payable for non-workmen is capped at $2,600 per month. Non-workmen, as you would have realized earlier when I mentioned, they are basically rank and file white-collar employees, like, for example, a clerk. Okay, so their overtime rate is a cap of $2,600 per month. There's no cap for the workman, the manual worker overtime salary. Now, next point is for public holidays. All employees are entitled to 11 public holidays in the year. They are all gazetted holidays, right? And the last point here is annual wage supplement or the 13th month payment, which is like a bonus. This is not compulsory. So for employers to pay, but most employers will make a payment of the 13-month salary as a bonus. And over and above that, there are employers who routinely give, further bonuses over and above the 13-month payment. Right? Next slide, please. Now, this section is on part 4 rather, of the Employment Act. What I have discussed earlier, they are called the core provisions of the Employment Act. In other words, all employees are entitled to those provisions mentioned there. However, for part 4, they do not apply to managers and executives. They don't apply to PMET, right? So they only apply to those who are the rest of the employees, the workmen and the non-workmen. And this relates to hours of work, overtime, and rest days, right? So for, as you can see, I've mentioned there, workmen are those earning up to $4,500 per month, and non-workmen are those get up to $2,600 per month. The hours of work mentioned, provided in the Act is 8 hours per day, 44 hours per week, if the employee is working more than 5 days per week, right? But there are some who work 5 days or less, then it's 9 hours per day or 44 hours per week if it's working 5 hours per day per days or less per week. So depending on number of days that they're working, basically it's 44 hours per week or either way. All right, and the last point here is payment for overtime work. There are at least 1.5 times hourly basic pay has to be paid. Sometimes if an employee is working on a public holiday, then the employee is entitled to a day off or payment in lieu for the public holiday. Right, next point, please. Next slide, please. Now, this is on annual leave. The entitlement for annual leave is a minimum of 7 days for every year of service. And as the employee works longer, for every additional year of working, the employee is entitled to 1 further day of annual leave in a year, up to a maximum of 14 days. But some employers, you will notice they will give straight away 14 days, and even they will increase the number of 14 days to 21 days as the employee works longer and longer in the company. Now, to qualify for an annual leave, an employee must have sort of served a minimum period of at least 3 months with the employer. Right? Next slide, please. Now, this relates to compassionate leave. Under the law, there's no right provided for employers to allow any compassionate leave to an employee, but employers will usually allow between 3 days to 5 days is quite common. So what I've been saying, they're all the basic requirements under the Act. Most employers will give more than what the basic requirements are stipulated under the Act. All right, next slide, please. Now, when an employee falls ill, then the employer has to recognize the medical certificates issued by any registered doctor or dentist. There were occasions before where the employer insists on the employee seeing a particular doctor engaged by the employer. But right now, that restriction doesn't apply. So any registered doctor or dentist who issues a medical certificate will have to be recognized by the employer. Entitlement for paid leave, the employee is entitled to 14 days of sick pay leave in a year, or up to 60 days if there's hospitalization which is required. And this includes full reimbursement of all the medical fees that is incurred by the employee. All right, next slide, please. Now, this deals with retrenchments. Now, employees who are either citizens or permanent residents, they are eligible for retrenchment benefits if they have served at least 2 years with the employer. The amount of retrenchment benefits or compensation will be based on negotiations between the employer and employee. Usually, if there's unionized employees, then the union would have an agreement on this point in the collective agreement which they negotiate with the employer, between the union and the employer. If an employee is not unionized, that in other words doesn't belong to a union, then the employee can negotiate directly with the employer. The prevailing practice is to pay between 2 weeks to 1 month's salary for each year of service as by way of retrenchment benefits. Right. Next slide, please. Now, this dispute resolution, there's a new provision which is included over the last few years on handling disputes between employer and employee, particularly regards to salary and wrongful dismissal. So before the Ministry of Manpower was handling, but now they've organized it in a different manner. First of all, be handled by the Tripartite Alliance for Dispute Management, TADM for short. And the way they would do is they will hold a mediation session between the employer and an employee and try to explore an amicable resolution of the dispute. If the matter is not resolved by mediation, then the dispute will be channeled to the Employment Claims Tribunal for adjudication, where the tribunal will make a decision on the dispute. Claims for wrongful, I must say that at the Employment Claims Tribunal, lawyers are not allowed to represent clients, so the disputing parties will have to represent themselves. The second point here is claims for wrongful dismissal must be filed at the TADM within 1 month from the last date of employment. So this is quite an important point, because if the deadline is missed, then the employee or the employer may have to bring the dispute into the court system. It doesn't mean that the dispute or the rights are exhausted. They can still be pursued, but within the court system. So managers and executives can also seek this route to seek the redress. They can, if they have served for the employer for at least 6 months. Right, next slide, please. Now, this is the second part of my presentation where the impact of COVID-19, which has got on some of the issues relating to employer and employees. Now, although we have just opened the phase 1 on the 2nd of June, so I'm sure you're all familiar that there are certain restrictions which are still in place. Namely, the advisory from the government is we still need to work from home as much as possible, and telecommute or do teleconferencing as much as possible. And thirdly, to divide management and staff into different teams so that they don't sort of interact with one another. So if one team is affected, the other team can still manage the operations of the company. Fourthly, there's a requirement for daily temperature taking. Fifthly, you need to scan through the safe entry and exit when entering any workplaces or exiting any workplaces. And sixthly, We've got to observe safe distancing even within the workplaces. And finally, we got to wear face masks, not just when we go out, but also in the workplaces. So these restrictions are there, and this has to be observed. Secondly, employees who are working full time, they of course need to be paid the prevailing salary. This applies to both local and foreign employees. Thirdly, employers can apply to the Ministry of Manpower for flexible work schedule. Now, this arrangement allows the employer to make some kind of cut some costs in terms of work which is being done and perhaps pay them as overtime over a longer period of time. But whatever scheme that they propose or they have in mind, they have to get the approval of the Ministry of Manpower. They have to apply to the ministry, get their approval before this flexible work schedule can be put in place. Now, finally here, the employers can ask employees to take annual leave or take no pay leave up to about 4 days. This is part of the cost saving measure. So if there's no work, the employees can consume the annual leave, which is on a paid basis, or take no pay leave for about 4 days. Right, next slide, please. Now, the next point here is from March this year, the Ministry of Manpower has allowed employers to make adjustments to salaries of their staff, management and staff. So, but however, they have to do it in a manner which is fair. In other words, it cut across both management and staff in a fair manner. So that's another measure of cost cutting which the MOM is allowing. Right. Next point, employees on home quarantine order, or they are on leave of absence or stay-at-home orders, they are all entitled to be paid salaries. Right. This is not due. So while they may not be working, they're still entitled to be paid their salaries. Next point, employers are entitled to some financial support under the job support scheme. So as part of the funding that's required by the employers who face some difficulty in paying the staff salaries because they might not be getting enough business or enough revenue or cash flow problems. So the government is providing some funding for employers for job support for the months of April, May, July, and October. And this is to help the employers to retain the employees so that when things turn around, they'll have the manpower available to operate their businesses. Another cost-saving measure is that employers are entitled to waiver of the foreign workers levy from March to May. So March, April, and May, they don't have to pay foreign workers levy. This is to help employers to retain their foreign workers. Right? Next slide, please. Now, just now I mentioned the point about taking no pay leave. So employers are discouraged from asking staff to take prolonged no pay leave. So the suggestion is about 4 days, but they can ask them to take more, but they are discouraged to do so. Next point is about retrenchment. Employers are also discouraged from retrenching employees. If an employer wants to make any retrenchments, and if there are more than 10 employees in the company, then the employer is obliged to give prior notice to the Ministry of Manpower. The purpose is so that the ministry and the unions and other or NTUC, they can try and find some suitable replacement jobs for these employees who are going to be retrenched. Now, last point on this slide is the employers are obliged to maintain and upkeep the foreign employees who are not able to work because of the pandemic. So however, the salaries can be adjusted and the leave arrangement, this has to be worked out between the unions and the employers or between the employees and the employers. Okay, next slide, please. Oh, I've come to the end of my presentation. So I'll be happy to field any questions if you have.
Thank you so much, Attorney Ranvir. That has been very comprehensive, but we do have a lot of questions coming in. Before I start reading some of the questions, there was this line that you mentioned in the previous slide about no pay leave. I wanted to ask, what if someone wants to take more than 4 days of no pay leave? What should that person do? What can you advise?
Okay, if it is the employee who wants to take more than 4 days, then I'm sure the employer will have no objections, because that helps the employer in saving costs, since the employee is will not be paid during that no pay leave period. The idea of the 4 days suggestion was to help the employee so that the employee will get paid. So it's striking a balance between saving costs for the employer and also the employee being paid in good time. Otherwise, the employee will have no income. So, but if like I mentioned, if the employee is the one who wants to take a longer no pay leave, then I think that's not a problem.
Oh, okay. Thank you very much. We do have some questions from our Facebook.
Mhm.
There is one question here. What if you got sick when you are in the Philippines during your annual leave? Can an employer recognize the sick leave?
Right. So if the employee has a medical certificate, and the medical certificate can be presented here and perhaps be verified by the doctor here, then I'm sure that will have to be accepted. Otherwise, I'm sure there'll be some way of recognizing, for example, a certificate given in the Philippines. Well, so it's a matter of just verifying that the certificate is authentic, proper, and so on, in some way or other, and then it should be recognizable here.
Okay, thank you. There's
Yeah.
another question again on leave. If you are given an LOA or SHN, that's leave of absence or stay home notice, is that going to be part of your sickness leave? Some employers deduct it from your regular leave. How does that?
It shouldn't be deducted from the sickness leave, regular leave. Are you talking about the hospitalization leave?
It just meant, yeah, it mentions Sony mentioned LOA or SHN. So
Okay, it shouldn't be deducted from regular leave. If you are talking about if you mean regular leave by annual leave, then it shouldn't be deducted from annual leave, but it can be part of the hospitalization leave, because there are 60 days of hospitalization leave which is given.
okay, so that becomes
Yeah.
part of that
Yeah,
hospital.
but certainly not part of the annual leave, because annual leave is quite different.
Okay, so annual leave stays on.
Stays on, yes.
Another question from Payeng Etarama. In time of pandemic like this time, I hear from some of my friends that some employers are giving their salary too late, like more than 7 days, because of cash flow issue. What can you advise on this matter?
Yeah, so although the 7 days is the time limit mentioned in the Employment Act. So of course, what is stated there, is meant for the usual time, the usual course of things. So now, there being a problem which the employer is also facing, I guess it's a matter of just, giving some latitude both ways. But if you go by the rights, then the employee is entitled to get paid within 7 days. And if the employee doesn't get paid within 7 days, the employee is entitled to bring the complaint to the MOM or to the TADM, where I mentioned a dispute on salary can be brought to the tripartite, dispute management, TADM, which I mentioned earlier. It can be brought up to them for mediation purposes.
Okay, thank you. So there you go. You can go to MOM or to the TADM.
TADM, yeah, TADM.
TADM if
Yes.
it's more than 7 days, or if you're
Yes.
still not too happy.
Yes.
So there are some places to go to resort. Another question. From Richie. Hi, Richie. What do you mean by independent contractor? Is this an individual person or is it under company that will provide manpower? I think it's a clarification question.
Yeah, so independent contractor can be a person, it can be a company, it can be a partnership, a sole proprietorship, or private limited company. Usually one of the rules of thumb is if the employer is not making payment of CPF for say A who is working, then usually A is not considered as an employee, it's considered as an independent contractor. An employee means a CPF has to be paid. Of course, there are some relationships where A is treating B as an independent contractor, but the law can treat that as an employee and get the employer to pay CPF. So there has been some disputes around this area before. But the general rule of thumb is the independent contractor doesn't have to be a company. It can be an individual.
Okay. So as long as there's no CPF, you're not an employee.
On the surface, yes. But like I'm saying, sometimes there are situations where actually there is an employer and employee relationship, but the treatment is given as independent contractor, but the law can treat that as an employee and make the employer pay CPF. So it all depends on it's quite fact specific, depending on the actual arrangement that they have between the employer and the other party.
Okay. Okay. We're having a few more questions.
Okay.
Jang, hi. Few employers now are having pay cuts. How much is allowed? Is there a certain percentage mandated by law?
Okay, the law doesn't mandate any percentage, but if you recall just now I discussed, the MOM is allowing employers to have some cost-cutting measures, but this has to be fairly done across the board. This has to be done fairly across the board, including management.
Oh, that's the key, including management.
Including management, yeah. So it goes across the board. So if let's say they are cutting 10%, then it may be 10% across the board, or it might be the management is taking a bigger pay cut and the lower ranks are taking a smaller percentage of pay cut.
Attorney Ranvir, how would you know that it's applied to all the employees? It's usually a confidential matter when they do.
Yeah, that's a good point. I mean, if a complaint is made, for example, to the MOM, then investigations will have to be made by the MOM. And during the investigations, they can always get more details which the employee is not able to get.
A quick question. If I'm going to MOM, do I have to spend so much just to go and have MOM investigate? Because maybe some people do not feel like they would like to go to MOM if they feel that they're treated unfairly.
Yeah, so the first port of call is obviously the TADM, but they are the ones to try and resolve disputes on salaries. If that cannot be done, then of course there are other avenues to do so. So at this point in time, in some of the implementing these measures, there could be some issues. For example, whether an employee can find out what is the cut being fairly made across the board. He or she may not be able to find out. Then it's only by making a complaint that some of these investigations will reveal what is the true situation.
Oh, okay. Thank you. Next question is from Ronald Yinti. Is the $100 per day quarantine order allowance for person under QO? Is the allowance $100 per day? Is that for the employee or for employer? So that's a clarification question.
Yeah, earlier on, when during the pandemic, there was this payment of $100 to the employer, and then it has to be paid over to the employee. So right now, I believe the funding for $100 a day has stopped to the employer because the government is providing job support, right? Funding by way of job support. And because of the funding provided by job support, because it's across the board, they have stopped giving the $100 per day to the employer.
Okay, so that there's no more $100 support right now.
Yeah, no more.
Thank you. Josie Jean is asking about retrenchment for Singaporeans and PR. Are foreign workers also entitled for retrenchment benefits? What is the minimum posed by the law? Minimum amount.
Yeah, I believe the retrenchment benefit does not extend to foreign workers. It is confined to citizens and permanent residents.
Okay. If you are working from Austria, Jen, if you're working and considered as essential worker, is it still allowed for the company to cut your salary of about 15%?
Okay, again, this is a point related to the earlier one. If there's any cut, it must be justified. It must be fair. If there's unfairness in the cut, then obviously there's something has gone wrong, and it becomes a ground for complaint. You know, a ground for dispute on the salary.
I think there's really a big concern on the salaries. People are really worried about pay cuts. I guess it's happening everywhere. So that's a major concern for everyone. There's another question, this time from Len Salvador Bacanto. Past renewal was rejected, and it seems like it's because of the salary given the COVID situation. Can the past be renewed based on the old salary?
The salary is a measure of what sort of pass a person should be getting, and that shouldn't be a ground for rejection of the pass. So for example, S pass has a certain a ceiling limit, or employment pass, or the PEP. So that's quite a different issue. The rejection, one has to see what is the reason for the rejection for the pass. You know, so one has to look into what is the actual grounds for rejection of the pass. It can't be salary, because it can't be based on salary. But of course, one cannot apply for, S pass when one is supposed to be applying for E pass, for example, right?
Oh, okay. Thank you. Just wondered, please send your questions on Facebook Live. We are looking at our Facebook site, so if you have more questions, even the ambassador, if he has a question, please feel free to ask. And any of our members, please feel free to ask. Don't be shy. Next question. Oh, Attorney Ranvir, some business, how to contact you? Somebody says Godville.
Oh, okay.
Cillian.
Oh, well, Bayanihan Center.
There you go. Workplace bullying. I did mention that earlier.
Workplace bullying. Okay, workplace bullying.
Sorry.
Yeah, I suppose for bullying, it depends on what is the bullying all about. If it's one has to understand what's the nature of the bullying about, and of course there are avenues to seek redress for bullying. These kind of things are not tolerated. So there are avenues to seek for redress depending on the nature of the bully. Right? A person can take even private summons for protection from harassment, for example. If there's harassment, if there's some discriminatory practices, that can be also room for redress against discriminatory practices, whether on grounds of gender, or grounds of race, or grounds of religion, or whatever. And these are not tolerated, as you know. If there are harassment relating to sexual matters and so on, that of course they are, they do take a tough stance on this kind of position. So there are rooms of redress depending on the nature of the bullying, and of course grounds for redress are there.
I think if I may just ask, bullying is a little bit subjective also, but any advice from you on how we can protect ourselves from bullying, or how would we recognize that this is bullying? Any kind of conditions or situations where it's, especially when it's not too obvious?
Well, from my experience, I've come across where people will send nasty messages, right? Or so that one you can make a report to the police for a start, right? For police for a start. So at least there's a record of this kind of incidents, which can be used as evidence in court later on. that person can take action under the Prevention of Harassment Act. For example, if a person is harassed, right? So that's a criminal matter, and the person can take out on his own, right, a personal action under the Prevention of Harassment Act. There are provisions for that. So that's one. Secondly, I've come across situations where some members of a female, sex were not promoted or given because of some sexual bullying, so to speak. And so of course that we don't have a law on for employment matters where sexual um, matters are related to, for example, promotion and so on. But there are criminal laws which can be activated to deal with this kind of problems.
Okay, because I think sometimes it gets a bit difficult, and people tend to be shy, or just they want to keep quiet so they don't create problems at the workplace.
Yeah, I understand. So sometimes when the matter gets, when tolerance reaches its limit and the person take action, but there are avenues to redress all different natures of bullying or harassment that there may be.
Okay, thank you so much. I
Right.
hope that helped. Another question from Ronald. So the QO allowance, this quarantine order allowance, employer will claim from MOH and should be given to the employee. My employer did not give to me my allowance, as she said that I'm not entitled because I got salary during my QO period. I got a salary because I'm working from home. Is it correct that I'm not entitled?
Yeah, so if the employee is paid salary, then there's no need for an allowance to be given because the employee doesn't lose out in terms of income. Earlier on, the employer was given this allowance by the government because the employer could not use the services of the employee. So if the government hands out a home quarantine order, the employer loses the services of the employee, for example, for 14 days, right? So the government will then fund for the 14 days to the employer because the employer loses the services. But now with the job support scheme coming in, that is helping to fund the employer in order for the employer to pay the employee his wages. So if the employee is paid the wages, then the employee is not entitled to an additional $100 for that per day quarantine period.
Okay. Okay.
Yeah.
As long
If
as
the
you take
employee,
the full
yeah,
day, be
if the,
happy.
if the employee is not paid his wages, then obviously he'll be entitled to something.
Okay. All right. Thank you. Another question from Ed DC. If you're asked by your employer to work outside the office or at site, but you personally am afraid or you are afraid to go out at this time, can an employee reject such a request? What consequences will the employee face, if any? Any protection for the employee?
If the work is dangerous, I'm not sure what kind of work in this situation, this example, right? But if it's within the scope of the employee's work, then obviously the employer can ask the employer to work. But if it's not within the scope or it's dangerous, then it can't. Okay, for example, let me give more concrete example. Like for example, if FDW is asked to clean windows and all that exterior, now that is quite dangerous, and the MOM doesn't permit that. Unless there are safety, um, steps taken for. Otherwise no. The employer, the MOM, in fact, advises employers and FDWs to sign like a safety agreement. So they both have understanding as to what sort of work can be done and what cannot be done. In other words, dangerous work, cleaning on the exterior, that is not allowed. Cleaning windows from the exterior is not allowed. So that's an example of what if the employer asks the employee to do, then they shouldn't be doing it.
But if still the employee doesn't want to do it,
Now,
it's not that dangerous. So it's just the feeling of going outside and work.
yeah, if it's going outside, then one has to see what is the nature of the danger that we are dealing with. If it's dangerous and is outside the scope of the work, then obviously the employee doesn't have to do. If it's dangerous but within the scope of the work, then the employer is first of all obliged to take measures to take care of the safety of the employee. If the employer, that's the duty of the employer doesn't take reasonable steps for the safety of the employee, then the employee can decline to do so.
Okay.
There must be steps taken to safeguard the safety of the employee.
So safety is top priority.
Of course.
Yes. A question from Ms. Lala. Who pays for the repatriation ticket of retrenched workers?
Okay, usually my understanding from my experience has been that the employer will have to pay for all repatriation tickets, air tickets, up to the nearest point to the employee's country, town or in the particular country.
Okay, so employer pays for the ticket that's been retrenched, for the
Right.
ticket of the person that has been retrenched.
Right.
Okay. Any question? Maybe the ambassador has a question.
No, I don't have. I have a question, Ranvir.
Yes.
There is salary support, right?
Yes.
And the government pays up to 75% of the salary in certain cases,
Right.
just so that the employer is able to retain the employee.
Right.
But is there any way, does the government check that in fact that's happening? Meaning it's not that the employer has actually already retrenched his people, but is still claiming 75% of their salary. How does the MOM check that?
It's a very good point. Yeah, I guess this is the checks and balances. I think they will be able to check through the CPF, for example. So if A is retrenched, then there'll be no longer any payment of CPF. I mean but CPF is only relevant to the
To
local
local
and
employees, yeah.
permanent residents, right? It
Yeah,
doesn't cover for those who are on work permits,
yeah.
right? Yeah. So they will then look at the levy payments. For example, work permit, there's a payment every month. Now, if there's some declaration which made which is not correct, and if they're caught, I'm sure such things can surface quite easily. Someone will make a complaint, and then if the employer is found not to have paid over the monies, and then they're still collecting it, they've actually retrenched the employee, then of course the employer will be in hot soup.
Yeah. No, because that's a concern is that we're seeing certain employees being retrenched, the OFWs, but the government has in fact put in some support system to, including waiver of foreign levy and
Yes.
foreign worker levy, as that also rebates of previously paid levies, right?
Yes.
So I guess I'm just a little bit wondering if the government, I guess the government at some point will double check to make sure that people are not abusing the system.
Yeah. Yeah. I'm sure when there's a complaint made, they'll investigate into all the alleged abuses. And if there are abuses are found, then I'm sure they will claw back the money from the employers.
Okay, thank you.
We've got another question from Celine. She's talking about hospitalization leave.
Yes.
Yes. So if an employee has been given 90 days, but she only has taken 60 days, can the employee be allowed to come to the office even if she didn't finish the 90 days leave?
Yes. I mean, if the employee thinks she is fit to work and wants to come back and work even before completing the hospitalization leave, obviously the employer will be quite happy to do, the employer will be quite happy for her to come back. So there's no restriction for her to come back. It is for her benefit. The leave is given for her benefit to recuperate.
I think the company wants her to The way I understand it, the company wants her to come back in 60 days, even if she was given 90 days leave.
Oh, then I mean, the employer cannot force her to do that. The employer cannot force the employee to come back before the completion of hospitalization or medical leave. If the medical leave and hospitalization leave is that the employee is unfit to work, then the employee has a right to complete the leave period. Right? The only difference there will be the employee is entitled to 60 days of hospitalization leave in a year. If the employee has got more than 60 days of leave given by the doctor, then technically speaking, for the extra number of days, the employee will be on no pay leave, or the employee will have to use the annual leave, for example. Annual leave is a paid leave. So what they do normally is you finish your hospitalization leave and then consume your annual leave, and if still balance, then there'll be a no pay leave thereafter.
Oh, okay. So if you're forced to go back before you finish your hospitalization leave, you can
decline. The
decline.
employee has a right to decline because the employee is still on leave.
Oh, okay. Just back to an earlier question about being forced to work outside. The question was that there is during this current pandemic. Does that make any difference if it's during this current pandemic or during normal situation?
Well, even during normal situation, the employer is obliged to take safety measures for the employee. And under the current pandemic, the obligation will be even much more onerous for the employer. It must take even more extra precautions for the safety of the employee. Like, for example, there's this requirement to wear masks and having sanitizer and so on, and safe distancing, even traveling in company transport or whatever. So the employer has to take all these safety precautions. Plus, at the work site, safety precautions is a must, even during normal circumstances, wherever the workplace is, from the equipment to the place, to the premises, and so on. They have to give sufficient equipment and take sufficient safety precautions for the safety of the employee. And safe methods. So they have to do risk assessment that the methods are safe, the method of working.
Okay. Hope that answers the question. And we've got a question from Mr. Stephen Chia. Hi, Mr. Stephen. The question is about an FEW doing a transfer during this current period. But instead of being transferred, the FDW would prefer to go home. What is fair, and who will be paying for her ticket to go home?
Okay, usually
during this CB period.
Usually, I mean, there will be an employment agreement signed between the employer and FDW. So I would imagine that there'll be an employment agreement signed before the FDW came to Singapore, or at least when she first came to Singapore and before she started work. And in this kind of agreements, my understanding is, where I've seen most of them are, the employer has to pay for the repatriation cost of the FDW, even if there's a transfer.
So the previous employer has to pay?
Yeah, so it's subject to that agreement, and usually the agreement will provide for this. If there's no agreement signed and all is silent, then it becomes a problem. Then they'll have to negotiate between either one or two employers and the FDW as to who is to bear this cost. Is to avoid such a problem that the agreement is usually signed beforehand, before the FDW even starts work. And in that agreement, this is provided for, catered for as to who would bear. Usually it's the employer who bears the cost of repatriation.
Okay. I hope that helps, Stephen. Okay. Ariel is asking a question. He has been working on site since pandemic has started. Is there compensation for him?
Okay. I mean, there isn't sort of extra compensation mandated by the law, but the law states that if you are working, then you then you have the right to get paid salary on time, and that's a minimum. There's a minimum mandate that you have to. I mean, they must be paying salary on time since you are working. But beyond that, for any extra compensation, that isn't provided for under the law. But I guess most employers who are appreciative, they might give something extra.
Okay. Any other questions? Please feel free. Last question from board members. Anyone from the embassy? Anyone? Before we end this session, I think I hope it has been very fruitful so far. Question from anyone? Can I ask a question if no one is raising? Attorney Ranvir, what was the most fun case that you ever had regarding employment issues? And what was the most difficult case you've had so far on employment issues?
Yeah, well, the problems usually centers around, when some people who are asked to leave for reasons which they feel is unfair. It's like unfair dismissal. Sometimes there are employees who have worked in a company for many, many years, and then they are asked to be dismissed. And the most unfortunate thing in some of those cases are where they don't have a clearly set out agreement. So I think that's why the most important thing is to have a clear contract of agreement between the employer and the employee, which provides for as much of these terms and conditions within the agreement, including retrenchment benefits. Many a time, these are not thought of at the point where they sign the agreement. So as you can see from what we have discussed, for example, foreign employees are not entitled to retrenchment benefits, right? Only citizens and permanent residents are entitled under the law. So they should provide for this in the agreement as well. Retrenchment benefits, for example, and other benefits. So first of all, an agreement, properly comprehensive drafted agreement is important. So the problems that I've come across, or I won't say the interesting cases, but sometimes the problematic cases are where people have been retrenched, sometimes even very senior management. And the more senior they are, they don't even have, and if they don't have this in the contract, then they have no rights under the law.
Yes.
For those workmen and non-workmen who come under the purview of the Employment Act, they have a mandated right under the law to claim for retrenchment benefits. But those who don't fall the purview, they don't have.
Yeah.
So right now, of course, professionals, managers, executives, and technicians fall into the purview is to protect their rights. So they'll have a minimum of 2 weeks to a month's salary for each year of service.
Yeah. Okay, thank you so much. Okay, so we reached the end of our discussion on employment laws in Singapore. I think a lot of concerns were about pay and leave. And according to Attorney Ranvir, please make sure that you have a contract. And in the contract, please include retrenchment benefits as well, if you can. As well, I would suggest also medical benefits. And if for foreign domestic workers, the repatriation benefits. So please make sure that there is an agreement so that at least we have something to fall back to in case there is a disagreement. Best is if you have a union in the company, then you have extra protection for your benefits. Okay, so may I call on Christy to give closing remarks? Christy.
Hello.
Okay.
Hi, I think we missed something. We might be able to squeeze in one last question to Attorney Ranvir. I saw one last question. It's a quick one, but Richie wanted to know, is it mandatory to have employment contract?
It is not mandatory to have an employment contract, but it's mandatory to have the terms and conditions set out clearly. Just now I discussed in one of my slides, but then if you that doesn't really help very much if you just set out the terms in writing. You need to have an agreement. So I think it's advisable, although it's not mandatory, it's advisable to have a contract. So it's binding in nature between the employer and employee.
Okay. With that, we learned so much, of course. And we need to say thank you for all the people who work very, very hard behind the scene. We have Edward Binluan, of course, one of our board members, and our center managers, Cecil and Mindy. And of course, we want to say a special thank you to June Rigunan of Rated J, who helped us with the trainings. Of course, His Excellency Ambassador Joseph Yap, maraming salamat po for joining us tonight and making this extra special. And we hope to see you in the coming webinars. And for all the people who help us to spread the invites despite very limited time and help us gather so much number of participants. We have Netfield, care of Pastor June, the BNG team, FLPH, care of Rex and Richard, Wilford, thank you, Doc Eugene of FAUS, Rose of FAUS, Miss Jeng of UPAS, and the Kuro Kuro team for broadcasting the invite in 2 of their sessions. And of course, we want to say thank you, maraming salamat po for all the participants. You have been a very, very good participants in putting out your questions that made this a very informative session. Without you, we cannot call this a success, of course. And this inspires us to continue to do what we are doing or what we have started. And join us again on 25th of June. So we have a lined up that will be on a Thursday still. And it will be with our volunteer doctor from FAUS, Doc Eugene Makalinga, and he will discuss health in the time of pandemic. So join us again in a very informative, another very informative session.
So that's the end of our first ever webinar. We all look forward to see you again on June 25. We'll have something about medical benefits. Thank you so much. Thank you, everyone. And thank you also to Amba.
Oh, we can do a little shout out for the people who joined us here. We saw Margarita Locsin. Hi there. You were the first to come in. Richie, Mr. Stephen Shia, Arnold Apostol, Karen of PNB, Rose of FAUS, Jeng of UPAS, Mike Abdul, I saw you there, Paeng of IIEE, these are the electrical engineers, Enik Teo of FAST, Virgie Galera, Austin Jen, I hope I said the names rightly, Gabriel Sansalian, Ronald Intig, Ed DC, Ariel Ojena, you're there, I saw you, Paeng, and a lot more, Austria Jen. So maraming salamat po. Join us again on 25th of June. Back to you, Minnie.
Okay, okay, and that's the end of our first ever webinar. We look forward to more. Please send suggestions also of topics and speakers, and we will look into them. Thank you so much. Thank you all. Good night.
Thank you.
Thank you. Thank you.
Thank you, Ranvir.
Independence Day
Thank you,
po.
Ambassador. Thank you, everyone, and good night.
Night.